Swayam Prabha. Digital India. Educated India.
Hello everyone, welcome to lecture number 12 of our course on law of copyright, patent, trademark and other IP. We started talking about procedure for grant of patent. If you recall, in the previous lecture, I gave you the flow chart of the patent process, which starts with filing, then publication of application followed by examination. There are two stages when the patent application can be opposed. One is called pre-grant opposition, the other is called post-grant opposition. What will happen to the granted patent, whether granted patent shall be published, within what timeline the post-grant opposition can be filed. I introduced some ideas in the previous lecture, and out of all these stages, if you remember, I discussed the filing and publication part. In filing, I introduced the different kinds of patent applications which can be filed in Indian Patent Office. I talked about three kinds of patent application, one which is directly filed in Indian Patent Office, the second is PCT application, the third is convention application. We discussed who can file, we discussed what is the appropriate patent office where you will file. Keep in mind that India goes by the rule of first to file, that is, one who is first in filing the application is entitled to get the patent. We are not following first to invent rule. Most of the cases follow first to file rule because, as I mentioned in the last lecture, it is a more objective method of deciding the question. Towards the end, I was talking about publication of application. I said publication is something which is important so as to alert public that there is an application filed and anybody having an objection can come up and raise his or her objection. I also said that publication is a stage from where some provisional protection starts, although you will not be allowed to file for infringement because you have not been granted the rights which a patentee gets under section 48 of our act. We will talk about these rights later on, but some kind of provisional protection starts because now your invention has to some extent come to public domain, it has come in public knowledge. So, we discussed filing and publication in the previous lecture. This is the second part of procedure for grant of patent, and we will be talking about examination of application. You have the flow chart here in front of you. This has been done, application has been done, and after filing of application, a request for examination has to be filed. Now, that request will be filed within 48 months, if you see here, within 48 months from the filing or from priority date, whichever is earlier. So, within 48 months from date of filing, you have to make a request for examination. Now, there is a slight change here. The recent amendment of patent rules make it 31. The recent amendment of patent rules 2003 changes this timeline. Now, within 31 months from the filing or priority date, whichever is earlier, one must file a request for examination. Because if request is not made, it is considered as withdrawn under section 11(b)(4). Under section 11(b)(4), your application is considered as withdrawn if no request for examination is filed within 31 months from the filing of priority date, filing date or priority date, whichever is earlier. There is another point which I would like to mention here is, if there is a secrecy direction, there is a secrecy direction. What do we mean by secrecy direction? You see, there are certain inventions which are related to national security, are sensitive inventions. In relation to those inventions, central government may impose certain secrecy directions. And as long as the secrecy direction is on, such applications cannot enter into the stage of examination. So, this is an additional point which we have to keep in mind, that in relation to those inventions where secrecy direction is on, a request for examination can only be filed within 6 months from the date of revocation of secrecy direction. So, the general rule will otherwise apply that within 31 months from priority or date of filing, you must file your request for examination, but there is a special reference of secrecy direction. As I already mentioned that under section 11B4, if a request for examination is not made, the application is considered as withdrawn. Now, once the request is made, the controller refers the application to an examiner. The controller refers the application to an examiner, and he has to do it within 1 month from the request. So, you make a request for examination here, within 1 month the controller has to refer your request to an examiner. Examiner will submit his report within 1 to 3 months. So, a request for examination is made, controller refers the request to the examiner within 1 month from the request, an examiner gives his report within 1 to 3 months. Now, what all is there in the report? You see, section 12 talks about grounds, patentability grounds, some of the grounds. It will talk, the report will talk in detail about the grounds of patentability, and it is also important to mention that this report under sections 12 and 13 are considered as something which is quasi-judicial. It is a quasi-judicial which the examiner performs, quasi-judicial function which the examiner performs. Now, once that report is submitted, it is submitted to the controller, and mind, there is another important point which is contained in section 144, which says that the report which is submitted to the controller is a confidential document and it is not open for public inspection. Point number 1. What do we mean by confidential document? Section 144 of the Patent Act says the report of the examiner is a confidential document which is given to the controller. It is a confidential document means it is not for public inspection, point number 1. And second, it is not liable to be produced in any legal proceeding. So, it cannot be produced in any legal proceeding. So, under section 144, the document is a confidential document. Now, anyone who has filed the request for examination, the applicant, he receives a copy of the examiner's report. Now, the important question here can be Why I am saying that anyone who has filed the request for examination? Because it is not that only the person who has filed the application will only be interested in examination of application. Try and understand. There may be many other companies, there may be many other people who may be interested in getting my application examined because they may be willing to oppose my application. They may be interested in the outcome of examination process. So, it can be the request for examination can be filed by the person who has filed the application for grant of patent, or it can be filed by any person who is interested. So, therefore, applicant can be even person interested, person interested. So, an applicant will receive, the applicant who has requested for examination of patent application will receive the examiner's report. Now, this is important. From the date of request to the date when applicant receives the first examination report, the total duration shall not be more than 6 months. So, this is an important timeline. The time period required for an applicant to receive the examiner's report is 6 months from request for examination. So, the date when you made a request for examination, from that date to the date when you receive the examiner's report, the total time which will go will not exceed 6 months. I hope it is clear now. Now, once the report is received by the applicant, there are two options, two possibilities. One is the report may be favorable. Kindly read this word favorable. Kindly read this word favorable. One is the report may be favorable, the other is the report may be adverse. If the report is favorable, that means it is patentable, there is no objection. In that case, the patent shall be allowed, patent shall be granted, there is no difficulty, there is no problem. So, I am the patent applicant, I requested the controller to examine my application within 31 months from filing date. Controller refers my request to the examiner, examiner gives his report, a copy of the report is given to me and that report is favorable. I fulfill the requirement of patentability, in that case patent shall be allowed, patent shall be granted. The problem is when there are adverse comments in the report of examiner. Now, those adverse comments can be of two kinds. There may be technical objections, there may be substantive objections. Technical objections may include objections related to forms, fees, specification. You have not filed the correct form, you have not deposited the appropriate fee and so on. These technical objections are not very difficult to resolve, and therefore, if the applicant for patent, if the person who has filed the patent application is in a position to comply with the objections, he may insist on hearing, that is a different thing. Even after hearing, if he complies with the requirements, if the technical objections are cured, then patent shall be allowed. The real problem comes when there are substantive objections. Substantive objections would include objection related to patentability, patent eligibility. The examiner of patent may write that the invention does not fulfill the requirements of novelty, inventive step, industrial applicability, or the invention falls in one of the entries of section 13. If that is a situation, then there are two possibilities. The applicant may agree to the objection, the applicant may disagree with whatever are the findings of the examiner. If the applicant agrees that yes, the observations of examiner are true, then in that case he may go ahead, modify his invention, modify his application, make amendment in his application, and after modification, after amendment in the invention in the application, if the substantive objection is cured, after amendment, if the substantive objection is cured, then it is a case of grant, the patent shall be granted. But if the applicant disagrees either wholly or partially with whatever examiner says in his report, then in that case the patent applicant has to justify, has to present arguments in support of his disagreement. And that is a case where a request for hearing may be made. You see, if the applicant disagrees, he can request for hearing, and his request of hearing must come within 1 month of the report of examiner. On the basis of request made by the patent applicant for hearing, after hearing there are two possibilities. The controller may accept the adverse comments to be right, or the controller may disagree with the comments given by the examiner. If the controller agrees with the comments given by the examiner, then controller will refuse to grant patent. However, if controller agrees with the applicant, patent applicant, and in fact disagrees with the examiner's report, then in that case patent shall be granted. So, this is the step of examination, and there are few more observations which are important. If I sum up whatever I have done here, an applicant files a patent application. The patent application has already been published. Now, anyone, the applicant himself or some interested person, can request for examination. The controller refers the request to the examiner. Examiner gives his report. If no request is made, the application is considered as withdrawn. So, the proceedings will stop. So, therefore, a request comes, the controller refers the request to examiner, examiner gives his report, that report is given to the controller, a copy of it will be given to the person who has made the request. As I said, the report may be favorable, it may be adverse. If it is favorable, there is no problem, patent shall be granted. If it is adverse, the comments can be, there are technical objections or there may be substantive objections. Technical objections may be cured, technical defects may be cured by amending the application, maybe by filling the right form, by depositing the correct fees, and if the problem is cured, patent shall be granted. The problem is with respect to substantive objections, objections like patentability, patent eligibility. In those cases, if the applicant of patent agrees with the objections, he may go ahead, modify his application. If the defects are cured, patent may be granted. If the defects are not cured, or if the applicant of patent disagrees with the observations of examiner, he may contest. He may contest means he will have to give justification for the disagreement. He can request for hearing, and after hearing, controller has to decide whether the controller agrees with the observations of examiner. If he agrees with the observations of examiner, patent shall be refused. If he disagrees with the observations of examiner, that is the case of grant of patent. So, this is the mechanism. Once the report is received, come here, once the report is received, if there is no response to the examiner's report, if there is no response to the examiner's report, it is considered as abandoned. The proceedings will stop there. So, the applicant has to respond to the examiner's report. Now, as I said, from the request of examination to the stage when the applicant receives the examiner's report, this time period is 6 months. Now, from the stage of applicant receiving the examiner's report to this stage where the controller takes a decision whether the patent is to be granted or not, this is again next 6 months. So, this is the timeline within which the process of examination of application is to be completed. So, therefore, from the step of an applicant making a request for examination to the stage of applicant receiving the examiner's report, the total time which will go is 6 months, and from this stage till the decision of the controller after hearing this portion, this part will take another 6 months, and this is the timeline within which the stage of examination of application is to be completed. Now, there are few relevant points in the step of examination. As I have already mentioned, there can be no examination unless there is a request for examination. And you see, you will find it in the entire patent process that almost every step of the patent process is subject to request, subject to a form filled by the applicant, and subject to payment of fees. So, if no request is made, there shall be no examination. I said if no request is made, it is considered as withdrawn. There is an important clause in rule number 24C of Patent Rules 2003. If you see, Patent Rules 2003 was amended and a new rule, rule number 24C, was included, and this was included to encourage certain entities for filing for patent, because you see, your new IPR policy 2016 talks about giving importance to IP filing also. So, it is not that scientists and the inventors will only be interested in inventing. Government requires them to go ahead and file for patent application, and in last 15 years, last 10 years mainly, the trend is very positive in terms of filing of application. The grant has increased by 200%, patent filing has increased by 400%, the manpower is also increasing. So, therefore, the entire mechanism, the entire ecosystem of patent filing to grant is improving these days, and it is all happening because of the declarations which we made in our IPR policy of 2016. One of the changes which you see is in Patent Rules 2003, where 24C provides for expedited examination of application for startups. If an application is filed by a startup, then the law provides for expedited examination process, and you save time. You save time at two stages. One, where the examiner is making report, and second, when the examiner is issuing statement of objection. You save some time at this stage when examiner makes his report, and you save time at this stage of issuance of first statement of objection. And this expedited examination is allowed. This expedited examination is allowed for startups. There is another point. A regular request for examination may be converted into a request under Rule 24C. So, you made a request for examination under Rule 24B, which is a regular request, and you may now request that my application be converted into an application under 24C because I have this status of startup. What do we mean by startup? Innovation based activity of certain value for certain duration, which is scalable. The definition which you have in startup policy of Government of India shall apply here also. So, therefore, this is not the only example of expedited examination. We have some flexibilities available in our patent rules for educational institutions, for women entrepreneurs, for women inventors. An important point which I would like to mention here is for educational institutions, universities, and for startups, patent rules grant 80% discount in payment of fees. So, in payment of fees, you get an exemption of 80%, not only during the process of obtaining patent. The discount is available even at the stage of payment of annuity fees for maintenance of patent. because I already mentioned that once patent is granted, in order to continue that patent for 20 years after the grant, every year you will have to pay patent maintenance fee, and you get 80% discount if you are a startup or if you are an educational institution. So, these are some of the important observations in relation to examination. Section 18 of the Act, Patent Act 1970, talks about functions and powers of the controller. Controller may accept the application, controller may reject the application and deny you the grant of patent. Controller will do all the communications with the applicant. Controller has the power to take a decision on divisional application. So, these are some of the responsibilities of the controller. I already mentioned in that chart which I presented that examiner is required to submit the report to the controller within 1 to 3 months from the date of reference. I said once a request comes to the examiner, once a request comes to the controller, controller will refer that request to the examiner. From that date, within 1 to 3 months, the examiner has to give his report to the controller. Controller will review that report within 30 days from the receipt of the report. I already mentioned that the report is confidential. What do we mean by that? There are 2 points. 1, it is not open to public inspection, and 2, it is not liable to be produced in any legal proceeding. Now, if you recall, I said in my previous lecture also, I said that in the entire process of patent filing to grant and after the grant, there are 2 occasions when a request for opposition of patent may be filed. One is called pre-grant opposition, the other is called post-grant opposition. As the name suggests, one is before the grant is given, the other is after the grant. Post-grant opposition can be raised within 12 months from the date of grant. We will come to post-grant later on. Let us see how pre-grant representation or pre-grant opposition is done. Pre-grant opposition will be done after the publication of application. If you recall, I said the first step is filing of application, the second step is publication. No application shall be published until the expiry of first 18 months. Till that time, that application is considered as a secret document. Once it is published, it is open for public inspection, and if you remember, I said when the application is published, what all do we publish? Name, address of the applicant, date of application, number of application, and the most important thing is abstract. That abstract contains the technical features of the invention, the problem which the invention solves, the gist of the solution. It also mentions the title of the invention. So, on the basis of whatever is written in the abstract, one has to take a decision whether he wants to oppose that application or not. I also mentioned that those who are interested in opposing the application may want to have access to the specifications, the description of the invention. Those who want to challenge the application may be interested in the diagrams which the inventor has filed, or the sample which is deposited in international depository. Now, all these things are accessible on payment of fees. And once I am sure that I am now going to file a representation, for me then the process of pre-grant representation becomes important, because I have made up my mind that there is some problem in the patent application, there is some problem in the invention, and I must raise it to the controller of patent. Now, if you look into this chart, after the publication of application, anybody can file representation. Anybody can file representation means statement. If you look into the chart, you see statement and evidence in support. When you file representation, you will have to mention, you will have to give evidences in support of your opposition, and you can do it by filing form number 7A any time before the grant. So, after publication till grant, it is open for pre-grant opposition, and I have mentioned it here that the grounds on which you can oppose, these grounds are mentioned in section 25 subsection 1. Now, there are two possibilities. One, your representation, your opposition may be refused. The other is your opposition may be accepted. In both these cases, the matter will be reviewed by the controller, and after the controller reviews it, there are two possibilities. Controller may reject the opposition altogether, and if the controller rejects the application, he will grant the patent and will declare that there is no merit in the opposition. Or he may grant the patent with slight modifications, small modification in the patent application, finding maybe some merit in the opposition. That's a simple case. I filed opposition, you have merit in your invention, you have merit in your application. Controller, after reviewing your invention, your application and my opposition, may finally decide who wins, and accordingly a decision for grant of patent will be taken. That's not a difficult case. The difficult case is the proceedings will go ahead if controller finds that the patent application can be refused or requires amendment on the basis of my opposition. If he decides, if the controller decides that there is some merit in opposition, then he will forward the same to the applicant. You have filed an application for grant of patent on your invention. I am opposing your application. If some merit is found in my opposition, this will be referred to the applicant of patent. An applicant will have to file his response. You see, he has to file response. It is written that he has to file in 3 months. This is contained in rule number 55 clause 4 of patent rules 2003. This rule has been amended, and now the timeline has changed. The applicant has to file his response in 2 months. The recent amendments of patent rules is expediting the entire process of patent filing to grant. We saw that how examination request will now be made within 31 months from the date of filing, which used to be 48 months at one point of time. Now here, once the controller finds merit in the opposition, he will refer the matter to the applicant. An applicant has to respond in 2 months. Hearing will be given before the controller if the applicant requests, and on the basis of hearing there may be two decisions. Kindly ignore this thing. Either patent will be granted or patent will be refused on the basis of hearing. So this is the entire mechanism of pre-grant representation. Keep in mind, there are few important points. For example, rule number 55(1)(a), which says that no patent shall be granted before the expiry of 6 months from publication. No patent shall be granted before expiry of 6 months. So, from the date of publication, the grant shall not be given until expiry of 6 months. This is one important point, so that any person get adequate opportunity to oppose the patent application. As I mentioned, there are changes. One change is here. Recent amendment has reduced this 3 months into 2 months. Now, in addition to this change, there is one very important change which has come. Now, coming to this point, and if you listen to me carefully, after publication of application, any person can file representation. The very idea of pre-grant opposition is that anyone is allowed to file pre-grant opposition, so that pre-grant opposition becomes a mechanism to help patent offices in examine the application. Because you see, patent offices, despite employing the best diligent effort, may not be able to take a correct decision. So, therefore, anybody is allowed to raise an objection so as to help the controller in coming to a right decision as regards granting or refusing to grant patent. So, it is a mechanism to assist patent office. It is not essentially a matter between the applicant of patent and the person who is opposing. It is not between them inter se. It is a matter where the person raising the opposition is actually helping the patent office. And therefore, it is not called technically as opposition, it is called as a representation which I make to the patent office. Now, this basic idea has been changed, because if I am trying to help the patent office, should the patent office ask me to pay fees? No, because I am, by raising opposition, I am trying to help the patent office to come to a sound judgment. But unfortunately, what started happening, see, it was originally conceived as something which has a very positive purpose, that people, anyone can come up and help the patent office, raise objections, raise those points which probably patent office skipped or may skip. So, therefore, it had a good objective, but people started abusing the provision, and there will be good number of frivolous objections, kind of benami objections, and this had to be regulated. Lawmakers started realizing that there are many frivolous objections coming in the name of pre-grant representation, because it used to be free. So, people won't mind filing n number of pre-grant representations if they want to delay the whole process of granting patent. And foreigners, countries like USA will never like a mechanism of pre-grant opposition, because they would say that this is only a mechanism to delay grant of patent to non-Indian applicants. So, therefore, an amendment has been done in 2024, by way of which what has happened? We have introduced fee structure if somebody wants to file a pre-grant representation. Although it may not be a right thing to do if we accept this to be a mode of assisting patent office. However, in order to discourage people from raising frivolous objections, this point has been raised. And the fee structure, rupees 4,000 to 20,000 fee structure has been prescribed. As I have already mentioned, in entire patent process, individuals pay lesser fee, companies and firms will pay more fee. Same is the case here. If an individual, if a person wants to raise a pre-grant representation, he will be paying rupees 4,000 fee. If a company wants to raise a pre-grant representation, the company will have to pay rupees 20,000. This is one change, but this is not all. There are other points also. Now, if you come to this table again, this chart again, I have written that after the publication of application, anyone can file representation. In your representation, what you have to do, you have to give the statement and evidence in support of your objection. What are the evidences? Why do you want to oppose? Now, that is it. Your job is to give evidences. Now, what law says, a rule has been modified and you are asked to establish prima facie case. You have to establish a prima facie case when you raise the representation. And if no prima facie case is made, then hearing will be given, after which the controller will dispose of the matter by passing a speaking order, and it will all happen in 1 month. So, therefore, what we had prior to amendment was that the only responsibility of the opponent was to give evidences in support of his points. Now, the opponent has to establish a prima facie case, which becomes a difficult task for him. And if no prima facie case is made out, then controller will stop the proceedings there itself by passing a speaking order within 1 month's time period. This is one thing which will discourage people from raising frivolous objections, and the other point which I mentioned was payment of fees, which may be 4,000 for individuals and 20,000 for companies. So, fee payment becomes mandatory. That is how the very nature of pre-grant representation has changed. So, these are the changes done in 2024. There are few points which I will quickly mention. If you look at this slide, Rule 55(1)(a), I already mentioned that no patent shall be granted before the expiry of 6 months from publication. There are grounds on which pre-grant opposition shall be made, and the grounds for opposition are identical whether you are filing a pre-grant opposition or post-grant opposition. In both these cases the grounds are identical. I have listed some of the important grounds. You can look into sections 25(1), 25(2) to know about these grounds more. The first is the invention is wrongfully obtained. You see in this list, the first is the invention is wrongfully obtained. That means if I steal the laboratory notes of some professor and on the basis of that I prepare the invention and go for filing, then anybody can oppose. So, if it is wrongly obtained. Second is the invention lacks novelty, the invention lacks inventive step, the invention relates to subject matter which is not patentable. Next, it lacks sufficient disclosure or is not enabling. Kindly understand this point. It lacks sufficient disclosure means when I have already mentioned that the specification part will describe the invention, and the description and the invention must be described in an enabling manner. Enabling manner means in such a manner that it can be performed by a reasonably skilled man in that art. So, if it is not described in an enabling manner, sufficient disclosure has not been made, that is a ground of opposition. Next, applicant withheld information or applicant disclosed false information. If you recall, in the last lecture I talked about section 8 where you have given undertaking that you will keep the controller informed about any foreign application in relation to same or substantially same invention, and if you do not disclose the information or if you give false information, it becomes a ground for opposition. Next, if you have filed the convention application in India after 12 months from the date when you first filed it in that convention country, then in that case it is a ground for opposition of patent. This is an important point. This is an important point. If geographical location of biological material is not disclosed or if it is wrongly disclosed. Why I am saying this is important? Because this is something which comes out of the interface between Patent Act, and Biodiversity Act. Biological Diversity Act requires us to adopt the mechanism of benefit sharing. Any invention which is based on biological resources, the benefit of that invention must be shared with people who have provided you the biological material, the starting material. How will I get to know whether the invention in question relates to some biological subject matter? It is only when we insist that the geographical location of that biological material must be disclosed. From where did you obtain that biological subject matter? Because it is only then we will be able to identify who have contributed in your invention, who have contributed the biological material in your invention. And once we know the contributors, once we know the contribution, then only we can go for benefit sharing. So, this point leads to a mechanism, the whole mechanism of benefit sharing. This is very important. Since I do not want to go in detail because this also requires some discussion related to traditional knowledge, digital library, it also relates with article 29 of TRIPS agreement. Those who are interested may study article 29, may study about TKDL. But this is a ground of opposition. If the geographical location of biological material is not disclosed, is wrongly disclosed, the application may be opposed. And the last point you see here, if the invention is nothing but part of traditional knowledge, if the invention is nothing but part of traditional knowledge cannot be misappropriated by anyone in the name of invention, and therefore, if that is the case, it is a ground of opposition. I have listed some of the grounds of opposition. There are more. Kindly refer to section 25 to look into more grounds. I have identified only the important ones, and you have the same set of grounds for pre-grant opposition as well as post-grant opposition. I said there are changes made. Now there is a fees prescribed, rupees 4,000, rupees 20,000 for making pre-grant representation. I said now you have to make a prima facie case. If no prima facie case is made by the person who is making pre-grant representation, then in 1 month time the controller will dispose of the matter. It is only when the person making pre-grant representation makes a prima facie case that the process mentioned in the table which I presented will be followed. Now, if pre-grant opposition fails and ultimately patent is granted, then what will happen according to section 43? The granted patent and the date of patent will be entered in the register. The granted patent shall be published in the official gazette and will be open for inspection. Official gazette, the Journal of Patent Office has been granted the status of, has been given the status of official gazette. So, all these granted patents are published in Patent Journal of Indian Patent Office. And once these are published, these are open for inspection, then anybody can raise post-grant opposition. Post-grant opposition starts once the patent grant is published. Notice of opposition is to be given within 12 months of publication. Now, there is an important point if you see here. Post-grant opposition can be raised only by interested person. It cannot be raised by any person, it has to be raised only by interested person. As I have already mentioned, the grounds are there in section 25. We referred to some of the important grounds. These are there in 25 too. The grounds for pre-grant and post-grant are identical. This is an important point, that it has to be raised by person interested. Person interested has been defined in section 2(1)(t) of the Patent Act 1970. Will refer to that definition. Any person interested who wants to oppose will have to give written statement and evidence. Now, an opposition has been filed. This will be notified to the patent holder. Now, a copy of the opposition will be given to the patent holder by the person who is opposing. By the opponent himself will provide a copy of his opposition to the patent holder. Now, while notifying the patent holder, controller is constituting something called as opposition board. This is another point of difference between pre-grant and post-grant opposition. Pre-grant opposition is disposed of by the controller himself, whereas post-grant opposition is disposed of by the opposition board. Now, if you come on this side again, patent holder is notified, patent holder has to contest. Patent holder has to contest the opposition and give his version within 12 months. So, you oppose my patent, I am notified, I get 2 months to give my arguments against your opposition. Once my arguments come in 2 months, those arguments will be given to you and you will again file your evidences against my evidences. So, this process will go on. In the meantime, the controller has referred the matter to the opposition board. All these submissions are going to the opposition board, and opposition board will give its report within 3 months. This has become 2 months now after 2024 amendment. After the entire process, when submissions were made by both the parties, opposition board has given its opinion in 2 months' time. Hearing will be given, and on the basis of hearing, patent may be revoked, patent may be continued if the opposition is rejected, or on the basis of opposition, some amendment may be proposed. So, this is the mechanism for post-grant opposition. There are 2 important points if you see. It can be raised by interested person and it has to be disposed of by the opposition board. Post-grant opposition, I said it can be raised by, it can be filed by interested person. Interested person is defined in 2(1)(t), any person engaged in or promoting research in the same field to which the invention relates. I said the matter will be disposed of by opposition board. Opposition board is a 3-member board. An examiner in the patent office is eligible to become the member of opposition board, and the examiner who has examined your application is not entitled to become member of opposition board in your case. There are few differences I have already raised between pre-grant and post-grant oppositions. As I said, pre-grant representation can be made by any person, whereas post-grant opposition can be raised only by person interested. Person interested has been defined in 21T. Pre-grant representation is disposed of by the controller, post-grant will be disposed of by the opposition board. I said pre-grant opposition process aids the examination process. It actually helps the examiner, whereas post-grant opposition mechanism is a proceeding between patent holder and the opponent. It is not a mechanism of helping the patent office. There is one significant difference in terms of appeal, and kindly listen to me for 2 minutes and it will be clear. I said pre-grant can be raised by interested person or any other person, right? So, pre-grant any person. If it is raised by interested person and if it is accepted, any acceptance or refusal is, any grant is done under section 15, an order is passed under section 15. Section 25 says that section 117A says that an appeal from 15 will go to the appropriate authority. So, if the opposition is accepted, then appeal can be filed in section 117A. If it is rejected, there is no appeal, because rejection does not come under section 15. In case of rejection, there are two possibilities. If pre-grant opposition does not succeed, you have an option of post-grant opposition, you have an option of revocation, we will talk about it, and in this situation High Court will not interfere. If the opposition is accepted, an order is passed under section 15, appeal is possible under 117. It is only when the pre-grant opposition is raised by third party and it is rejected that a writ under article 226 is maintainable. So, you kindly read this part to understand the difference between pre-grant and post-grant opposition in terms of appeal. In conclusion, what I can say that we have discussed an important aspect of patent prosecution in this part, which is examination. I emphasized on pre-grant and post-grant oppositions also. We saw that now, after the amendment in patent rules, more incentives are being given to startups and educational institutions. We have relaxed the process of examination. We have reduced the fees which is payable, and the reduction is to the extent of 80%. Pre-grant, there are amendments introduced in relation to pre-grant representation, which appears to discourage people from raising frivolous oppositions. So, we have concluded our discussion on patent procedure, patent prosecution from filing to grant. The next lecture will be on the rights, infringement, defenses and remedies. So, these four important aspects will be discussed in our next lecture. So, that is all in patent process. Thank you very much for attending the session.
Hello, I am A.K. Sharma and I teach sociology in IIT Kanpur. I am trying to answer a simple question: how sociologists explain their facts. As you know that sociology was developed as a subject dealing with human behavior, but which would use the tools and techniques of science, mathematics, physics, chemistry. But this view that human behavior needs to be studied scientifically has been contradicted later on, and it was said that simply by relating one kind of facts with other kinds of facts, you cannot understand human behavior. To to understand human behavior or to actually theorize about human behavior, you have to theorize the theories or motivations or meanings that people have in their mind in involving in a particular action. Now, using these two traditions, one tradition in which we relate one fact of society with other facts scientifically, and another tradition in which we try to develop second order constructs or theories that people have in their mind in acting in day to day life. They have produced two different traditions in sociology. One is called quantitative, another is called qualitative. Quantitative methodology uses scientific methods of conducting surveys, censuses, experiments, and then by using statistical methods, from simple methods like arithmetic mean to sophisticated methods like logistic regression, we try to arrive at some inference. Qualitative tradition, qualitative methodology on the other hand uses ethnographic approach, and here the researcher attempts to become part of the community which he or she intends to study, because the assumption is that only by becoming part of the community, by living among the people whom you are studying, and by putting yourself in their shoes, by trying to understand things or their environment or their behavior or their culture or festivals or economic behavior or politics from their angle, from their perspective, how they feel, what understanding they carry in their mind, that only by understanding these things we can understand facts of society. Actually, in one of the latest works, World Bank, which uses a lot of statistics, has also talked about understanding mental models that people use in involving in behavior. Emile Durkheim long back said that sociology uses comparative method, and let me just give one example and then I will finish. Suppose I tell you that infant mortality rate in India is 40. What does it mean? It means nothing. But when you compare infant mortality of India today with Japan and you find that Japan has 2 and India has 40, then you get disturbed. Then you start thinking, why is it that infant mortality in India is so high? And then you can also compare infant mortality of India with infant mortality of say Kenya or Mozambique or other countries, and you find that these countries have much higher infant mortality than India. And then you can create a hypothesis that perhaps economic development has something to do with infant mortality. Countries which are more developed, countries like Japan, they have low infant mortality. Countries like Mozambique or Kenya, which are less developed, have higher infant mortality. So, you have a connection. This is what sociology is about, connection between facts. So, by using census, surveys, by conducting field work, by using ethnographic methods, by using comparative methods, we arrive at sociological findings. Use of experimental method in sociology has been very less, but I learned that recently economists, which 10 years ago I could not see that economists will one day use experimental method, but today we find that economists are using a lot of experimental methods to study human behavior. Now, this work may be done by economists, but the findings of their study can very well be called sociological studies. So, sociology tomorrow, I think that sociology tomorrow, in addition to using surveys and comparative methods, will also be using experimental methods. Thank you.